welcome everybody. On behalf of UCL Centre for Law and Environment, along with my co-director, Dr. Pedro Schilling de Carvalho, I'm absolutely delighted to welcome you tonight to this evening's annual lecture, which is a very special moment in the calendar for the Centre, particularly for bringing together so many wonderful people who work in environmental law, friends, students, past students, current students, academic colleagues, those who work in practice, those who work in the third sector, government and so on. And we come together for a deliberately and unashamedly academic event on environmental law. I think, all of us who work in this field, I have to say, I'm too distracted by being a dean lately, but I still do work in environmental law. It's such an intense sphere for policy making, political contestation, media spotlight on the very real social and environmental contexts that the law relates to, that it really is important to have a moment where we kind of disseminate, debate, and celebrate the academic expertise that law brings to environmental issues. And that is a really important aspect of tonight's lecture. This year, we're absolutely delighted to explore themes of access to justice and the rule of environmental law. We're going to figure out what that means. Incredibly timely issues in environmental law and law generally. I was saying over tea before, last week I had a UCL work trip to India where I saw their High Court in Bangalore and the Supreme Court in Delhi. The most incredible system of justice, very dedicated to access to justice with implications for delay, but an incredible commitment to the dispensing of justice and the confronting of environmental issues within the justice system. And I was there on the day where they were hearing the latest instalment of the air pollution case in Delhi, on one of the record-breaking days of air pollution in Delhi. And 11 lawyers were dispensed to the entry points of the roads into Delhi to check that the orders of the court were being respected. The lawyers were sent out, which I know was extraordinary, and they were happy to go. Well, not happy, but very prepared to go. So, turning to our wonderful speaker, who has an absolutely prolific body of excellent work in environmental law scholarship, particularly on access to justice issues in Ireland, in Europe, and globally. Áine Ryall is a professor at the School of Law, University College Cork, where she shares a wonderful title with me, co-director of the Centre for Law and Environment. Very well-named centre, which I think Richard was very, made sure we had the name that way around for important reasons. Now, Professor Ryall is a graduate of her own university, that's right, UCC, and the London School of Economics. We won't hold that against you, that's the standard thing we say here. She also holds a PhD in European Union law from the European University Institute Florence. She's a barrister and was called to the bar in 1995. I actually don't know how you do everything you do, Áine, but I will persist with this. There was a much longer CV, but still this one's, it's a lot. But since 2021, particularly relevant for tonight's lecture, she's chair of the Compliance Committee to the Convention on Access to Information, Public Participation in Decision-Making and Access to Justice in Environmental Matters, the long title of the convention we all know as the Aarhus Convention. Committee member since 2015, vice chair since 2017, and now, as I said, chair. She's also a member of the Avoceta Group of Experts in EU Environmental Law, a vice president of the Irish Centre of European Law, and a member of the academic panel at Francis Taylor Building in London. And she serves on the Audit and Risk Committee of the Environmental Protection Agency in Ireland. Again, no small job. It's my absolute pleasure to welcome you, Áine, for your lecture on the rule of environmental law, some reflections on the Aarhus Convention. Welcome.
Thank you, Eloise. Good evening, everyone. It's an absolute pleasure to be back at UCL and to see so many familiar and friendly faces. I'm really honoured with the invitation. And before I start, may I just say a word of acknowledgement to Laura Howells, who literally made this happen and was superb in terms of the organisation. And having organised lots of these events myself, I know well how unforgiving event organising can be. So my sincere thanks to Laura. When I was an LLM student at LSE in the mid-90s, one of the courses on offer was environmental law and policy, and it was jointly taught at that time by UCL and LSE. And as it turns out, it was a series of seminars delivered here in Bentham House and taught brilliantly by Professor Jane Holder, who's here in the audience. It was Jane's seminars that inspired me and motivated me to look more deeply at environmental law. And that's the genuine article. It was Jane's seminars. At that time, I was fascinated by this implementation gap. I had never studied environmental law before, so this was a bit of a punt for me. You know, what would this be like? What would it involve? And it was very much the enforcement challenges around what was then, of course, European Community environmental law that Jane brought so very much to life. Back then, of course, direct effect was just beginning to find its way. Frankovich liability was something that was still so brand new, untried and untested. And all of that, of course, was pre-Aarhus. It's hard to believe now, but that was all pre-Aarhus. There was no Aarhus Convention then. And little did we know at those seminars that an international convention would ultimately prove to be, dare I say it, something of a game changer for environmental law enforcement. So standing here now, almost 30 years later, the invitation to give this lecture this evening is an opportunity, I think, to reflect on how far Aarhus has come in the intervening period. And I suppose to begin with a word of reassurance, I'm very conscious, of course, that many of you in the audience and those of you joining us online won't necessarily have that detailed knowledge of the intricacies of the Aarhus Convention and its compliance mechanism. And may I say how delighted I am to see so many LLM students here in particular, the future environmental lawyers and environmental law scholars and practitioners. And it's so important that you're here, and I look forward to engaging with you. As a teacher myself, it's often questions from students in my own LLM classes that I find the most challenging. Very obvious things that I just would never have thought of that really give you pause, and I struggle sometimes to come up with some of the answers. So hopefully we'll have more of that this evening too. But importantly, my remarks are aimed very much at a general audience and intended to offer some high-level reflections. And again, there is a complex process involved in the implementation of international environmental law. And I'm speaking very much this evening in my personal capacity. And you may have noticed I have something of a script. And again, this is because of the quasi-judicial nature of my role on the Compliance Committee. It goes against the grain, but regrettably, with my Aarhus hat now, I do have to be somewhat cautious in what I say. My overarching theme then is the rule of environmental law and the important role that the Aarhus Convention plays in supporting environmental law enforcement. But, and the but brings us to the question mark in the title here, at the same time as Aarhus having a very important role, as many of you will be aware, new points of conflict, new points of controversy have emerged quite recently. And we're certainly seeing evidence of backsliding on rights of participation and rights of challenge. And ironically, all of this is happening, of course, while the devastating impacts of climate change and the biodiversity crisis are unfolding all around us. So the starting point is that the rule of law, in my view, is under threat, and that the Aarhus Convention and the rights that it protects are more important now than ever before. So moving on from those preface remarks and turning to some brief introductory points, again just by way of setting the scene. The Convention, as many of you will know, is an international treaty, and the rights that it protects, they're designed to enable members of the public, which of course includes environmental NGOs, to act to defend the environment in the public interest. And that's important, to defend the environment in the public interest. There are currently 47 parties to the Convention, that is 46 states and the European Union. And the level of diversity found in the legal systems operating across those 47 parties, it's simply enormous. And to give you a flavour of the range that's involved here, if you think about it, in addition to the United Kingdom, the European Union and its 27 member states, the Aarhus parties include, for example, Ukraine, Azerbaijan, Turkmenistan, Armenia, and more recently, which might surprise some of you, Guinea-Bissau, a West African state. And for me, certainly as a lawyer, it's that diversity of legal culture that's one of the most fascinating aspects of Aarhus implementation. And what it means in practice, of course, is that different parties will experience different challenges when it comes to implementation of the convention, depending on their particular legal structures and their practice, as well as the domestic legislative, administrative and judicial architecture. And there is such diversity, and I'll return to that point later because it's a key element of implementation. It's important to recall too that there are, of course, multiple perspectives out there on the Aarhus Convention. Aarhus has its critics, the Compliance Committee has its critics, that's as it should be, and we're perfectly capable of defending ourselves where necessary. But my point is that each of us engages with the Aarhus Convention from a particular point of view, depending very much on our specific roles and how Aarhus impacts on our particular scheme of things. And again, the variety and diversity there is important. So taking myself as an example, over the years I've engaged with Aarhus as a student, as a member of the public, as an academic lawyer, and then as a member of the Compliance Committee, and now most recently as chair of the committee. So in my committee role, I'm exposed day in, day out to another very wide range of perspectives because I interact so regularly with parties to the convention, with communicants who bring the cases before us, and with observers who engage very closely with our work, and of course with the wider Aarhus community. So our individual perspectives on Aarhus will obviously determine how we regard its impact and its influence, how we see it developing into the future, and how we measure its success or otherwise in achieving particular objectives. It's important to bear in mind too that the impact and influence of the convention at both the national and the international level is very much a moving target, with new developments coming along almost constantly, and especially in the jurisprudence. Certainly as an academic lawyer, and I was mentioning this to Professor Stephen Vaughan earlier, I find it practically impossible to keep up. There's a new, potentially significant case almost on a daily basis now, and the danger of missing inadvertently some very significant development is very real. There's danger too, I think, and I'd be interested to hear what students think of this. There's a danger of being overwhelmed by the sheer volume of law and the sheer volume of analysis. And I'm digressing from my script now, which my secretariat would be very unhappy about, but I can't help myself. So just to say, because I was struck very much by Eloise's comments at the start, which I wrote down, because wearing my different hats now, my memory isn't as good as it used to be, so I now write everything down. But you mentioned about an academic conversation and that real and genuine engagement. And following on from that potential overwhelm point, there is, of course, and there always will be, that vitally important role for the rigorous academic scholarship that takes time to produce and to publish. But more and more now I find, and this is a little confession, I suppose, that sometimes very, very good blogs or podcasts can bring me up to speed in a way that I wouldn't have time for otherwise. So I think the role of more complementary approaches to scholarship, because it is a form of scholarship, is more and more important. And I think there is going to be more of an emphasis on that and being able to write what is a good blog or an impactful blog because of the sheer speed of things developing. And of course, it goes without saying the importance of open access is again fundamental. So then that was about the moving target, and I digressed. So moving then to the substance of the lecture, getting to the point, just very briefly in terms of structure, so you have some sense of where I'm going with this. Broadly, there's 3 loose parts to the talk. First, I'm going to draw on my engagement with the convention over the years to highlight some milestones along the way, looking or trying to look at that evolution of Aarhus, and what those milestones tell us about the challenges of implementing international environmental law. Second, I'll give a brief overview of the Compliance Committee, its work, and the significant pressures that it faces. And third, and rather briefly, as regards new points of conflict and controversy, I'll draw attention to the position of environmental defenders and wider threats that I see, and I'm sure many of you see, to environmental democracy and the rule of law. Starting then with what I loosely call evolution in the Aarhus context. So when the convention was adopted back in 1998, I was starting out as an academic lawyer, teaching and researching environmental law at University College Cork in Ireland. And at that particular point in time, it was the reception of European Community environmental law into the national legal systems that was a really big deal for academic lawyers and, of course, for practitioners and judges as well. And Professor Richard McCrory will know what I'm talking about here, because again, if you go back to the early days of the Journal of Environmental Law, that was such a huge theme, that there was all this EC law, yet it wasn't having the impact that it was intended to have because of resistance at the national level. And going back to Jane's seminars, this was what fascinated me. How could there be so much law, well-intentioned law, and there still be such an implementation gap? And you probably see where I'm going with this now. Of course, part of the answer is access to justice. If there is access to justice, the law can bite and people can use it, and hopefully things would change. But there's no doubt that there was at that time, and this again is back in the late 1990s, strong evidence of resistance to the impact of European environmental law. And if you think about it, the principle of effective judicial protection, something we take very much for granted today, it was nowhere near as well developed then as it is now. Judicial attitudes to enforcement of European environmental law were mixed, I think, to say the least. And there were those major procedural barriers to access to justice in environmental matters, including, of course, the cost of litigating environmental cases, certainly in the common law jurisdictions, where the scope and the potential for enormous amounts of costs against the unsuccessful litigant had a massive chilling effect. So it was against that particular background that I was drawn to Aarhus and quickly developed my interest in the access to justice provisions, because those obligations seemed to hold real potential to open up enforcement of environmental law. But it was difficult back then, very difficult in fact, to pinpoint what exactly the Aarhus provisions meant and how they might impact in practice in specific cases, because that's what counts. You can have a very nice shiny convention that promises a lot, but it's all about how you can make it work and make it improve environmental quality at national level. That's what's important. So a fundamental question that often came my way from practicing lawyers in particular, when I used to speak in public back in the late 90s about Aarhus, was challenging questions they would ask, like, what do the Aarhus obligations specifically mean in practical terms? What do they add? What, if anything, do they add? And how can they be made operational? So can we, for example, invoke this concept of wide access to justice, whatever that might mean, or the principle that costs must not be prohibitively expensive? Can we invoke those before our national courts? And at the same time, and on the other side, officials working in public authorities would challenge me in terms of the massive scale of resources that was going to be necessary to make the Aarhus rights work properly in practice. And public authorities, rightly, were very wary in that regard. Experienced officials could see the dangers here for public authorities in terms of them being inundated with new obligations and people calling on them to deliver these new rights. Yet would the resources necessary be provided? So that wariness was well meant, and it was also very prescient when you think about it, because traditionally under-resourced public authorities, they could see, in a way that perhaps government couldn't, the new and extensive resource obligations that were going to arise in all of this. So that is how things began back in my initial point of engagement with Aarhus in the late 1990s. And I mention it here because I think it serves as an important reminder of just how far things have come since then, but that it's been something of a rocky road along the way. But the improvements in access to justice, some of which we take for granted now, can be traced back directly to the Aarhus Convention. And since the convention entered into force in 2001, we've seen the Aarhus rights and the obligations created on states being interpreted by national courts and tribunals, by the Court of Justice of the European Union in Luxembourg, and of course by the Compliance Committee in Geneva. And over the years, the Compliance Committee has developed a sophisticated jurisprudence, and that jurisprudence, of course, continues to evolve. And importantly, the fact that the Convention forms part of the European Union legal order means that the Court of Justice has played and continues to play a vitally important role in interpreting and enforcing its implementation in the EU itself and across the 27 member states. But what became clear relatively quickly as the jurisprudence began to develop and national, EU and international courts got their teeth into the Aarhus Convention, as the content of the various rights began to be teased out, what became clear was that implementing Aarhus brought with it a whole load of significant implications for the national legal frameworks, and in particular for national procedural rules and remedies. It's fair to say that over time, the Aarhus rights have led to very significant disruption within domestic legal systems, and the precise nature and intensity of that disruption, as I hinted earlier, depends very much on local legal and administrative culture. Looking at the common law jurisdictions in general terms, the greatest impact, of course, has been around the cost of environmental litigation. Now, many of you will be aware there's what I will call unfinished business there, but it wouldn't be appropriate for me to comment on that particular side of things this evening. But beyond costs, Aarhus has influenced standing across quite a number of jurisdictions, in particular, of course, by demanding wider, more generous standing rules for environmental NGOs. And in other countries, it has led to changes as regards the availability of injunctive relief. So again, different jurisdictions have had different Aarhus challenges, whether it's costs, such as in the common law jurisdictions, standing, for example, in Germany and in Austria, and to a degree in Poland as well, and in some of the Eastern European countries, injunctive relief or interim relief and its availability has been an issue. Earlier this year, we saw the European Court of Human Rights in Strasbourg draw extensively on the Aarhus principles in its groundbreaking Klima Signorinen judgment. And that judgment, by any standards, provides a very striking illustration of this ongoing wider impact of the Aarhus Convention. But it doesn't stop there, of course, because in June of this year, in the landmark UK Supreme Court decision in Finch, it emphasised very much the importance of public participation. I was very pleased with Finch, I must say, and I probably shouldn't have said that either. It's off script again, but Finch, because I wasn't sure what way Finch would go. Could have gone either way. And interestingly, my own environmental law students at undergraduate level were fascinated with Finch from the High Court and were following it eagerly and getting very frustrated waiting for the Supreme Court judgment, because I'd set an assignment, that was kind of dependent on the Supreme Court judgment. We learn by experience. But it's very clear to anyone reading Finch at the Supreme Court level, certainly in the majority judgment, that the importance of public participation is there for all to see. And Lord Leggett made big of the point that the Aarhus Convention has been built into the EIA directive in terms of those public participation obligations. And at page 21 of Lord Leggett's judgment, where he engages closely with the rationales behind public participation, and I'm thinking again of Jane, of your brilliant book here, and he mentioned specifically education, awareness, the importance of participation. What he says there is, in my view, a tour de force, and I think something that is going to resonate for a significant period of time to come, probably not only in the United Kingdom context. Certainly we're taking note of it in Ireland, where our Supreme Court, in an earlier case about upstream emissions as opposed to downstream emissions, took a different view. So I do like his line at the very end of paragraph 21, this is Lord Leggett, you can only care about what you know about. Simple, elegant, powerful. You can only care about what you know about. So for those of us who believe genuinely in public participation, there's gold in that judgment. So it's helpful at this point just to move a little towards the process by which international law is gradually folded into the domestic legal order. And this process, as many of you will know, isn't necessarily a smooth process. There are many challenges that can and often do arise along the way. And just to say again, speaking personally, that as chair of the Compliance Committee and having served on the committee for many years, that we are very conscious of those struggles. Nobody is saying that implementation is easy. Sometimes people get the impression that we expect the impossible. We're just doing our job of applying the convention. So again, there are challenges and there will be difficulties. That's what makes it interesting, depending again on your perspective. Because if you're a state party, of course, this isn't interesting at all. This is something very, very different. But as I mentioned, the international norms, such as Aarhus, will often collide quite dramatically, sometimes, with deeply ingrained domestic legal and administrative culture. That is the familiar local way of doing things. And understandably, state parties are often very keen to defend the status quo, to defend the familiar local way of doing things. We've always done it like this. Who are you to tell us that this isn't compliant with international law? How do you propose we do it? Oh, we can't do that. And where are the resources to do that? And surely that can't be what the convention was ever intended to mean. And these are real conversations and real challenges. There's no magic wand here. But to recall again that states voluntarily subscribed to an international convention. They set up an international compliance mechanism. And domestic courts, the EU courts, the Strasbourg court, have the power and the authority to use the convention. So these are issues that we have to keep in mind when people try to knock, for want of a better expression, the Aarhus Convention. But there can be, and I acknowledge this fully, there can be very significant unintended consequences for state parties in the process of implementation. And they have to be teased out very carefully, and there's no doubt about that. And one of the key points in my talk this evening is that successful implementation takes time. It's not something that can happen overnight. And states need to keep that in mind, that you can't just quickly say, oh, we'll bring in new legislation or we'll do some training, without factoring in that it's going to take time to do that. And certainly in federal states, passing legislation, like until I joined the committee, I wasn't particularly familiar with the intricacies of federal states, but now I am. And if you think it's difficult to pass legislation in one jurisdiction, the federal nature of some of the jurisdictions is just mind-blowing. But successful implementation takes time. And it also requires, as I keep saying, that significant resource in terms of funding and expertise. And that's funding and expertise within the legal profession, the judiciary, the public authorities, NGOs, and civil society more widely. And international instruments like Aarhus, and this is important too, and people tend to glide over it, they raise very high expectations. When a state subscribes to international law that provides important rights and obligations, expectations are raised. That a rights-based approach will be applied, and individual members of the public, NGOs, local communities, they take these rights seriously and they come looking for those rights, as was the intention. So it shouldn't be a surprise that if a state subscribes to an international treaty, that people will then seek to enforce that treaty. But keep in mind that recognition of environmental rights is only the first step, and it comes back again and again to the quality of implementation and what happens, or sometimes what doesn't happen, at the local level. So making environmental rights work isn't a project for the faint-hearted. And it's necessary to be strategic and to engage persistently, often on multiple fronts. And I see a number of people who know what I'm talking about. I'm nodding there. It often involves playing, and I see this more and more the longer I'm in this. It often involves playing what often turns out to be a very long and challenging game. And you have to be in it for the hard graft. And I'm speaking, I suppose, to the LLM students maybe here in particular. This is a long game. But ultimately, you would hope it would be a successful one. But be conscious again of the question mark there. The rule of environmental law, yes, in principle, but. So when I'm invited to give talks on Aarhus, which is a very regular occurrence, I find myself now drawing more and more on the ideas of perseverance and resilience. Perseverance and resilience. Perseverance in the face of backsliding. I see backsliding all around me. And resilience in standing firm to defend the rule of law. And in all of this, I see access to justice, of course, not surprisingly, as being absolutely fundamental to the successful implementation of the Aarhus rights. And I take people's point that, by plugging access to justice, am I somehow then downgrading the information rights and the participation rights? That's not my intention. I started out, as Jane will testify again, that environmental information was one of the things that really grabbed my attention. I couldn't understand how in a certain jurisdiction, public authorities weren't making basic water quality information available to the public, that they genuinely thought that if people got this information, there'd be a panic. And you think, well, that's the whole point. Like, if people, but it comes back to Lord Leggett. You can't care about what you don't know about. And again, I accept this was back in the 90s, but you have to keep thinking about why is it that some information is so hard to get, even though you have a right to it, under national law, EU law, international law. But the point I'm making there is what? Oh yes, perseverance and backsliding. The access to justice. It provides that oversight and accountability and supports or should support effective enforcement of environmental law. But in practice, of course, it's proven to be a very difficult right to implement. And there's a whole set of complex reasons for that. But above all is the fact that delivering that timely, affordable, effective access to justice will require significant effort and often enormous amounts of resources from states, in particular in the common law jurisdictions. Somebody has to pay for this litigation. Somebody has to pay for the cost of access to justice. And the obvious problem then, of course, is that there are many calls on that pot, that limited pot of resources, and important political priorities at play. And I acknowledge that fully, absolutely. And again, emphasising that I'm not speaking here about any particular state party. These are just general comments right across the board. But tensions will arise in practice as to how to fund access to justice. And also from the state's perspective, how then, if you open up access to justice, how do you manage that tension between wide access to justice on the one hand and the clear necessity to deliver fast, dare I say it, planning decisions, or I should say in a timely manner, that your planning decisions come about in a timely manner, whether that's for housing, renewable energy infrastructure, public transport, the critical strategic infrastructure. And again, I acknowledge fully that, of course, decisions are urgent in those cases and that there's a public interest in that dimension as well. But while judicial review plays an essential role in ensuring our rule of environmental law, it's important that we don't allow, I suppose, I won't say the obsession with judicial review, but it's important that we don't get distracted from what's important, which is the quality of decision-making at first instance. If you can improve the quality of decision-making at first instance, and hopefully then reduce the need for review mechanisms down the line. So put the resources into shoring up the expertise and whatever is needed in the public authorities to get the decision-making right, if that's the correct term, at first instance, where that is possible. And I usually describe that as front-loading implementation of the Aarhus rights by putting those resources in at an early stage and then reduce the need for review mechanisms, as I said. And a big part of that, of course, is capacity building and sharing good practice within the public authorities. And I accept, again, just how stretched many public authorities are. But the reality is, without the resources, these rights will come under strain and there will be more enforcement activity. Turning then to the second strand of my talk, and that was the big strand, don't worry, I'm not going to go on for too long, but just talking a little about the Compliance Committee, and conscious that I'm constrained to some extent of what I can say. But the Aarhus Compliance Mechanism is a compliance committee established by the parties to the Convention. And I'm not saying that the parties brought this on themselves, but it was the parties' idea to establish a compliance mechanism. And we are given our mandate by the parties. And the states are, of course, bound by their Aarhus obligations as a matter of international law, obligations to which they voluntarily subscribed. And as is clear from the name Compliance Committee, we are absolutely not a court. The focus is very much on review of compliance and supporting parties to meet their convention obligations. So the committee comprises 9 members with expertise in environmental law, obviously, and international human rights law. We sit at the Palais des Nations in Geneva. And those of you who follow our work closely will know that we next sit in Geneva from the 10th to the 14th of December at the Palais with another very heavy agenda. So this is a live show. We just keep going. And I suppose looking back at my Aarhus journey, I've served on the committee since 2015. I was elected its vice chair in 2017 and have been chair since late 2021. So difficult and all as it is to believe, I'm now approaching my 10th birthday on the Aarhus Compliance Committee, or 10th year of service, whatever way you want to put it. But the current committee members, we have an excellent mix of practicing lawyers, law professors and judges, and drawn from across the Aarhus parties. That's important to reflect that diversity I talked about earlier. And conscious that I'm in the United Kingdom, and to give you an indication of the qualifications and experience of committee members, I'll mention that my committee includes Peter Oliver, formerly of the Legal Service at the European Commission, and Eleanor Sharpston, KC, a former Advocate General at the Court of Justice of the European Union. And Alistair McClone, a former Compliance Committee member and wonderful colleague, is here in the audience. So again, the calibre, I feel confident saying, the calibre of the committee members really is superb. And as chair, I'm fortunate to have super colleagues that are just so dedicated to the committee's work. And I should add, because many people don't seem to know this, but committee members are volunteers. We serve in a voluntary capacity, and this work is exclusively pro bono. We are volunteers, and we all have day jobs. But the compliance mechanism, just to move on, is very open in the sense that we receive communications, that's a nice word for complaints, from members of the public, including, of course, NGOs. And a lot of our business comes to us through NGOs, and there's probably no surprise there. In practice, what we do involves a quite formal process that has many of the characteristics of court procedures in terms of things, for example, like very strict approach to conflict of interest, careful attention to due process, holding what are very formal hearings at the Palais in Geneva, where cases are, I'll say it, hotly contested and taken very seriously by state parties, obviously, but also, of course, by the communicants. And we've a mandate from the parties to make findings and recommendations. And the recommendations are important, and they'll vary from case to case, but the aim, again, is to support parties to move into a position of compliance. So we might, for example, recommend legislative change, but there are also other recommendations that can be equally as important depending on the context. And I'm a big believer in recommending training and capacity building, whether for judges, prosecutors, state security services, legal professionals, public authorities, and others, as the case may be. And the committee then reports to the meeting of the parties. That's the governing authority. It's the representatives of the 47 state parties. And they then, the meeting of the parties, or the MOP, not COP, we're MOP, they have the power to endorse our findings. But once findings are made of non-compliance, that's not the end of the matter. There's a very important follow-up process, which again is very open and very transparent. And we rely very much on members of the public and NGOs to keep us informed as part of this process about what's happening or maybe not happening on the ground at local level. Parties found to be in non-compliance must prepare progress reports, to tell us what they're doing to meet the recommendations, and the committee in turn scrutinises what they're doing and prepares progress reviews. So there is a huge amount of work going on right now, scrutinising the progress of parties who have been found to be in non-compliance, and we then must report to the meeting of the parties. So that formal follow-up process does bring a lot of pressure to bear on states, and anyone with experience of compliance processes will know that it's political will and strong political leadership that's key to delivering change at local level, and of course making the necessary resources available as well. Very briefly, a less well-known aspect of the Compliance Committee's work, because a lot of it tends to be about the communications and how long it takes us to get through the caseload, the communications and the follow-up on implementation. But more and more now, parties themselves are coming to us, asking us for our expert advice relating to their implementation of the convention. So advice to parties is now a very significant tranche of our work. That work by definition is highly complex and time consuming, but again, it's good that parties are being proactive and coming to us. We welcome that, but again, our resources are limited. And it's public knowledge that the committee is seriously hamstrung by a persistent lack of resources. And sometimes the idea of this international human rights compliance committee sitting at the Palais in Geneva, that tends to get people thinking on the lines of this, stunning monolith that's really well-resourced, dripping with support and both legal and administrative. And I'm afraid the reality is very, very different. We have an excellent but tiny team in the Aarhus Secretariat who provide invaluable legal support to the committee in dealing with our ever-increasing volume of cases. But, to be clear, supporting the committee is just one element of that Secretariat's work. They are called on to serve as a whole range of different activities within their particular remit. And was it not for the Secretariat's dedication, our work would simply grind to a halt. Our work would simply grind to a halt. Again, it's public knowledge that since I took up the role as chair, I've regularly called in public on the parties to provide the additional resources that the committee so desperately needs. But regrettably, the position hasn't improved to any significant extent. And inevitably, the result is that the resources not being there, the processing time for cases is, well, considerable. There are other words that you could use, but it's considerable. And that state of affairs is enormously frustrating for those who bring communications to us. And of course, it's frustrating for states as cases limp on over the years. And it's especially problematic when states, like I said, come to us looking for advice, when we would like to get that advice out as quickly as possible. But again, we have to be sure that states can rely on our advice. So the quality and ensuring we can stand over it takes time. And the frustration for me as chair and for the committee colleagues, it's difficult to put into words. You have a compliance mechanism that the states created that's considered world-class if you go outside the UNEC region, yet we're not given the resources that we need. So while it's positive to see that we're in such high demand, without the resources, there are limits to what we can do. And I suppose that reinforces again the importance of access to justice and the effective remedies at local level. So then the very final strand you'd be glad to know about briefly new and emerging sites of contest. The Convention obviously protects persons exercising their Aarhus rights from penalisation, persecution and harassment. That's what the Convention says, and you find it in Article 3.8 of the Convention text. And recently we've seen increased attention focusing on the precarious position of environmental defenders, including children and young people. Including children and young people. And it's very concerning to hear about the increased use of SLAPs, the strategic lawsuits against public participation, and repressive measures to deter peaceful environmental protest. And again, I'm speaking generally, not about any particular state parties here. And in response to those grave concerns about the position of environmental defenders, in October 2021, the parties to the Aarhus Convention decided to establish a rapid response mechanism who could deal with allegations involving environmental defenders much faster than the committee could. And that mechanism takes the form of a special rapporteur on environmental defenders under the Aarhus Convention. So it's a very specific Aarhus mandate. And that in itself is a very significant development in the evolution of Aarhus. And if you think about it, the fact that the parties themselves found it necessary by consensus to set up this new mechanism, I think that tells us a lot about the precarious state of the rule of environmental law. It's a hugely significant development. And it's probably no surprise to you to hear that the Special Rapporteur is kept very busy and is very actively engaged with parties to the Convention. The Rapporteur is Michel Forst, a French national who was elected to the role by consensus by the parties in June 2022. And then, just more broadly speaking, as regards backsliding, I suppose it's very clear, probably to most of you, that where the backsliding on rights of participation and challenge is coming from is the intense pressure on governments to accelerate, which is the word always used, to accelerate environmental decision-making. And if you're going to accelerate environmental decision-making, by definition, that's going to come up against effective participation and access to justice. And those tensions, I accept, are not easily resolved. And it's going to be interesting to see how that all develops into the future, especially in the context of renewable energy infrastructure. So very final point then, moving to some quick closing remarks and attempting to pull the various threads together. I drifted off script. It was 35 minutes, but I'm nearly finished. Perfect. So just to keep in mind the convention, what it's all about, it's underpinning environmental democracy and the rule of law through the environmental rights that include participation and challenge. The fundamentals are important. And again, to remember what those rights are intended to do, to enable or to empower the public to defend the environment in the public interest. That's the intention. And the ever-increasing dangers, and we see them around us, to which environmental defenders are exposed, they are, without doubt, a cause of great concern. And again, I include here child offenders and young people who are so active now, especially as regards the climate crisis. But in my experience, the best way to protect the position of environmental defenders is to support and promote implementation of the Convention rights. If you get the Convention rights right, the rest should necessarily follow. So we have to work together to ensure that the Aarhus rights, participation and challenge, are normalised and generally accepted within society as a whole. And I genuinely do believe that the Aarhus Convention does stand as a beacon of hope into the future, because the rights are so important. They're so connected with everything that's happening around us, so connected to the rule of law. But we can't take those rights for granted. And when they come under threat, we have to be proactive, whether we're lawyers, students, chair of the compliance committee, judges, prosecutors, whoever we are. We have to persevere in the face of these new challenges, this new adversity. We have to be resilient and stand firm, again, to defend our rule of environmental law. And as I said at the very start, implementation of the Aarhus Convention is more important now than ever before. I genuinely believe that. And again, we cannot take it for granted. What comes can be taken away. And I'll just close by saying that I can assure you that the Compliance Committee stands firm and we will continue to lead the way to support implementation at local level. Thank you very much, and I look forward to your questions.